We'll have order in this tub. Bubble resolution number 4. In the tub of the liberal bubble, on March 7th, 2021, impeachment is being impeached for being an ineffective remedy for the removal of government officials abusing their power and betraying their oath of office. Resolved, that impeachment has never been successful in removing a president due to adherence to strict partisan
Point
lines.
of order, Mr. Skydoge.
The gentlewoman will sustain.
Point of order, Mr. Skydoge.
The chair will hear the gentlewoman from the other side of the tub.
See, I don't understand everything about impeachment and thus cannot impeach impeachment.
Yeah. Okay. The absence of a quorum has been suggested.
There is
will call the roll.
very obviously a quorum present.
The clerk will call the roll. Skydoge. Lady Gleep. Skydoge. Lady Gleep. Bark, Bjork, everybody. Hello and welcome to the 4th episode of The Liberal Bubble.
Howdy, hey.
Apologies. Yeah, hello, Glow. Thanks for joining me here today.
I'm here.
Apologies for all that procedural hubbubaloo at the top of the episode. I just had to call a quorum and research impeachment so that I could talk to you about impeachment before we impeach impeachment.
Exactly, and it must be done.
It must. Well, I submit articles that it must be done. I'm glad that you seem to already be on my side. This seems like it'll be an easy argument. But for those who don't know, a quorum is something that can be... A quorum call happens in the Senate whenever senators need time to confer amongst themselves. And so the majority leader will suggest the absence of a quorum, meaning that there's not 60 people present. And then the clerk will have to call the name of all 100 senators, like attendance. And they do it all the time. So
that's to stop someone from getting what they want on the other side, basically, or to help.
No, it's usually to get your house in order. Like if you don't know what's in the case of this impeachment trial, which we will discuss the specifics of Donald Trump's second impeachment in the next episode. But for example, on the final day, the Senate voted to approve the deposition of witnesses, which was not really in the House manager's plan. And so there was this huge scramble to get everyone on the same page as to whether or not they were going to call witnesses in this trial.
Yeah. And did they end up doing so?
They did not end up calling witnesses. Instead, they read into the record the statement of one representative who... We'll get to the details in the next episode, but she made comments about what she heard Speaker McCarthy saying to President Trump during the insurrection. I shouldn't say Speaker McCarthy. I should say Minority Leader McCarthy, because he's not the Speaker of the House. That is Nancy Pelosi. But with that being said, what's up, Chloe? What do you know about impeachment?
I feel like it's been a while since I've thought or heard about impeachment, because did it wrap up a few weeks ago? Or is it still
It wrapped up.
Yeah, I remember it not going in a way that I wanted it to, but I didn't watch any of it. That's what I know about it. I think I've kind of been out of the loop for a little. I haven't been doing my homework. I've just kind of been watching a little Seth Meyers, if you will, and I saw a lot of stuff on TikTok, which I sent you one. It was like Gen Z for Joe Biden, about how they're holding him accountable for dropping nukes.
No nuclear weapons were
no, I think
deployed.
What'd he do? I forget what happened in the video. He did something that harmed people in another country.
That is correct. What happened was the United States launched an attack on Iranian assets in Syrian territory, if I'm not mistaken. And there was no congressional authorization of that attack. This might be due in part to the fact that the AUMF expanded war powers for the president and was passed after 9/11, and nobody has saw fit to repeal that in the intervening 20 years. The AUMF, we can talk about in depth another time. It has little to do with impeachment, or nothing to do with impeachment, but it essentially allowed the president to take military action against non-state entities, like terrorist organizations in the wake of 9/11. That expansive authority to declare war and use war powers has not been revoked by Congress. It is Congress who has the power and the responsibility to declare war.
So when that happened after 9/11, was that an executive order or executive action type of thing? Like, how did that become a law that the president?
It was something that Congress voted on,
Okay.
and they passed. It was a different time. People were
Fearful.
very scared, yeah, and traumatized, and the powers granted under that emergency circumstance have yet to be repealed. Yeah,
that's crazy.
Exactly.
There's some things I feel like that aren't. There's just so many things that the government has to take care of and control that I feel like it must take much more energy to repeal things and like work on changing things in the past than to like work in the future. I don't know how to describe what I'm saying. But I feel like that's probably in the back, like not even in the car of the back seat. Honestly, it fell out of the trunk and no one turned to go get it.
I mean, every once in a while you'll hear there's actually bipartisan agreement about the repealing of the AUMF. Representative Ro Khanna, who is a Democrat, and Representative Matt Gaetz, who is a Florida Republican, and I'm not a fan of Matt Gaetz, but every once in a while he takes a position that I understand. Otherwise, he can be a pretty big hack in terms of Republican politics. But he and Ro Khanna co-sponsored a bill to repeal the AUMF. It did not really go anywhere. So there are rumblings in Congress. People want, especially after this particular attack, people are kind of upset, and they're like, that's not what the president is supposed to do under the Constitution. And we're going to talk a lot about the Constitution today. Today's episode, we are going to talk about impeachment. And I want to stay up front that I have an opinion on this, and it was that Donald Trump was guilty and ought to have been convicted by the Senate. And I think it's important that I state that outright up top. We are going to discuss the constitutional underpinnings for impeachment, the parts of the Constitution which talk about impeachment, outline how it's supposed to happen. But I have a very clear bias, and at times it will color what I tell you. I'm going to do the best that I can to indicate when I'm editorializing as opposed to like reading a quote from a nonpartisan source. And so I hope we can proceed with that in mind. I will do my best to do that.
And everything I say will be very biased with no educational background at all. It's just from my brain.
We love that. And I mean, we're gonna talk about the Constitution. We're gonna talk about some case law and jurisprudence as it relates to the Constitution. And that's what we're going to talk about this week. Next week, I want to get into the specifics of the arguments made by the House managers and the president's defense, so we can see how this process actually was applied, how it worked out. But ultimately, I want to tell you up at the top, I watched the entirety of this impeachment proceeding, and as the title suggests, I have soured on the idea that impeachment is an effective constitutional means for removing a government official who has abused or otherwise completely abandoned their responsibility to the Constitution and the people of the United States, and that conclusion is a matter of opinion. And I don't even have a constitutionally viable alternative to impeachment. I just think it doesn't work, and I'll lay the groundwork for that case today, and I'll bring it to a close next week.
We're laying it down. So get comfy.
With that said, I would like to begin debate on the question of impeaching impeachment.
Your nails look great still, by the way.
Thank you.
So good. Are they green? Dark green with one accent nail?
They are navy blue with an accent nail of glittery gold.
Beautiful. Just wanted the audience
thank
to know what I'm seeing.
It'll probably get cut from the podcast. First, I consulted an article from Cornell Law School. It states, impeachment is, quote, the Senate's quasi-criminal proceeding instituted to remove a public officer, not the actual act of removal itself. So, it notes that impeachment is often used kind of colloquially and informally to refer to the entire process from the beginning of the House of Representatives impeachment inquiry to the Senate trial to the actual act of removal pending the trial finds the official guilty.
I have a question. So, Donald Trump was tried for impeachment the first time, and it went through the House, but not the Senate.
It went through the House. There were lengthy hearings and depositions of many, many witnesses as they compiled information on the pressure campaign in Ukraine. Then the articles of impeachment were given to the Senate, and there was a trial. Mm-hmm. He was just acquitted.
He was acquitted. And now this was the second one that most recently happened. And was it basically like a repetition of what just had happened, or it was different? All right, I guess we'll talk about it next episode, right?
We will, but in terms of the actual substance of the impeachment, it is entirely different.
Okay.
In terms of the outcome, they're exactly the same. Mm-hmm. There was no accountability. Yeah. He was acquitted, or in other words, found not guilty. Mm-hmm. I would like to note that in this article, it describes the proceeding as quasi criminal, meaning that it is not a criminal proceeding. This is a point I will return to again and again throughout this episode. The impeachment process is separate and distinct from the criminal process under the judicial branch.
And what's quasi mean?
Quasi means like almost or approximating, but not exactly.
Okay.
It's like sort of criminal.
Criminal-ish.
Yeah, they're not the same thing. They don't unfold the same way. But the way that our criminal system indicts and tries individuals is a framework that is used to understand impeachment, but the legal standards and the processes themselves are not the same. Obviously, a criminal proceeding is a legal proceeding. So whereas a criminal proceeding is fully within the review of the judicial branch and subject to the processes of due process and the law, impeachment is a political process. It is something which the Congress alone can engage in with the exclusive goal of removing and disqualifying officials from holding office. It carries with it zero criminal penalties. As House Impeachment Manager Jamie Raskin made a point of saying many times during the trial, were Donald Trump to be found guilty, he would not spend a single second in prison. And so the two processes are not the same. We will get into more detail about that.
Wait, so then why were people saying, like, if Trump gets impeached the second time, he will, like, lose like his Secret Service and can be charged as a criminal for other things?
I think that's an excellent question. So I am not sure what would happen if a former president were impeached and disqualified in terms of Secret Service protection. I don't know if that would be canceled. In terms of his liability to criminal indictment beyond impeachment, either way, if the Senate were to have found him guilty or innocent, he is still subject to criminal proceedings, and we will discuss that later. Mm-hmm. It is explicitly mentioned in the Constitution. So Trump was always vulnerable to criminal liability, and if I am to believe anything I know about this man, he's very, very liable. Today we're going to talk about the Constitution. I'm going to read to you sections of the Constitution. If you would like, break out your copy of the Pocket Constitution. I know you all have one.
I can't tell you that I have ever read anything of the Constitution. Unless it was in a Nick Cage movie.
I think they steal the Declaration of
read it.
Independence. Yeah, no.
There's nothing to do with the Constitution?
I haven't seen National Treasure in a very long time. But I will tell you this. A lot of people think the Constitution's like a really long document. It's
a single piece of paper, isn't it?
It's just not that long. I mean, it was written on a piece of paper. It has been amended and lengthened, but like you could read it in an afternoon, easy. You could read it in an hour, probably.
Like 13 pages?
I don't know why 13 pages was. I don't know how many numbers. I guess it depends on spacing, and your margins. But the biggest thing you contend with when you read the Constitution is the actual language itself. It's written like it was written in 1789, because it was.
It's like Shakespeare government.
Sort of. Shakespeare is like a... I mean, it's not like a completely irrelevant comparison. Shakespeare is like kind of like a little bit more confusing to me, but the language isn't modern, and so the prose is a bit thorny. You'll see that as we talk about it, which we will right now. So the Constitution's broken up into articles. Article 1 has to do with the Congress. Article 2 has to do with the presidency, or the executive branch as it's otherwise known. Article 3 has to do with the judicial branch. And there are more articles, but those are the three that outline the powers of our three branches of government. The first clause, which is, I think, important to highlight, it comes from the second article, which is to say that about the president. Article 2, Section 4 of the Constitution reads, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." Now that phrase, high crimes and misdemeanors, is often, at least within these last two impeachment proceedings I've had the misfortune of watching, the subject of major contention.
I don't know how he went through two impeachments and like scathed both of them.
The reason he got by in both impeachments was because I don't believe impeachment works. If you go...
I mean, it obviously doesn't. How did Bill Clinton get impeached for getting his dick sucked in the Oval Office? But
that's
Donald Trump.
That's interesting. Okay, so here's Bill Clinton was ultimately acquitted as well on partisan lines for the most part. The problem with impeachment, just really broadly before we get into the nitty-gritty of the Constitution, is that when impeachment was written into the Constitution, political parties were not yet a thing. They became a thing very, very quickly. But the existence of a hyper-partisan dynamic was not on the brain of the founders as they wrote this mechanism of removal into office.
Yeah.
There have been...
I feel like the Constitution was basically when Albert Einstein created E equals MC squared, and he was like, fuck, I did a bad thing.
Literally, what are you talking about?
Like, you create something, but you have no idea of its power and capabilities, like what you're doing when you create something of genius or
Is E equals MC squared dangerous?
It was a part, like, that equation was the reason for, like, the atomic bomb.
I'm gonna fact check that.
No?
Please hold. I don't know. I'm a political scientist, not a scientist. It has to do with, okay, E equal MC square has to do with Einstein's theory of special relativity and an equivalence of mass and energy. I'm not going to get into the finer points of that because I'm more interested in the finer points of the Constitution today.
Yeah.
I don't believe.
Just redact what I said from this.
No, I will if you want. But the E is energy equals mass times the speed of light squared.
I just remember from my youth that it could just be a false memory that like he regretted coming up with that equation because it led to like mass destruction.
That may well be. I genuinely don't know.
So there's no parties before, like when the Constitution was made, everyone was just on the same fucking page, and then all of a sudden everyone was like, "Ooh, I disagree."
Well, the founding fathers were skeptical, some of them more than others, about the danger of political parties. They thought that it would pose a threat. But from the outset, from the outset, when it came to discussing whether or not the Constitution ought to be adopted as the governing document for our country, there was already pretty stark divisions between people like Thomas Jefferson, who would later characterize themselves as Democratic Republicans, and people like Alexander Hamilton, who would characterize himself as a Federalist. So there was like a robust debate prior to the adoption of the Constitution, and a series of essays called the Federalist Papers, which are basically persuasive essays arguing for the Constitution to be adopted.
Adopted by who? No, they already have fathers.
No, they are our fathers.
They're the founding daddies.
Exactly. Founding zaddies.
But zero sugar.
No sugar from them daddies. All right. Back to the content. The phrase high crimes and misdemeanors often gets misinterpreted to mean it often is presented as if a president must commit a crime to be impeached. This is a gross misreading of the constitutional text as I understand it, and I would like to go into that. And a lot of it has to do with the word misdemeanor. Originally, in an earlier draft of the Constitution, the term was maladministration instead of high crimes and misdemeanors, meaning if you were to comport yourself or do anything as a governing official that was really bad governance, you are subject to impeachment. It was later revised to high crimes and misdemeanors. I am not suggesting that we should abide by the drafted version of the term, but that it indicates, perhaps, what the Founding Fathers might have been thinking. Because here are what I understand to be the two options. One is that phrase, high crimes and misdemeanors, refers exclusively to crimes and misdemeanors under the criminal law and the Penal Code of the United States, and one to mean something more, something approximating maladministration.
So basically, are you saying that when Donald Trump was being impeached, the court was like, the things he did weren't misdemeanors, so they're not criminally, like, he can't be criminally charged?
No, I'm not saying that the courts ruled on that, because that's not their jurisdiction. Impeachment is exclusively within the jurisdiction of Congress, as we will discuss. I heard over and over again from Republicans that, like, what Trump is being accused of is not even a crime. Particularly in the case of the first impeachment, when he made that perfect phone call.
The one that was really perfect.
It was so perfect, the way he pressured that foreign leader perfectly. It was also a defense mounted the second time in regards to Trump's very incendiary speech on the 6th of January.
But would it have become, if that perfect phone call had, say like when he, say if the foreign leader like gave in and did whatever he wanted him to on the phone, would it have been one then, or did it not because it didn't like work? So like it didn't even happen, so it's not. Like I don't understand why they think it's not.
You're asking like a substantive question about the first impeachment.
Yeah. Like if that foreign leader did what Donald Trump wanted him to do on the phone call and it all went through, then would they have seen it as a crime, or just because it was inferred that Trump wanted that foreign leader to do it but he didn't, so then it's like, well, he didn't do it.
It's rather complicated. The thing about Impeachment 1.0 is that it actually is an incredibly complicated story, having to do with the State Department refusing financial aid to Ukraine, which is engaged in a hot war, an actual war with Russia. There were efforts in the Obama administration to deal with corruption in terms of prosecuting in Ukraine. Trump is trying to claim that he was doing the same thing. Unfortunately, Americans will never agree about the facts of this situation. So there's a video of Joe Biden saying that he will withhold aid from Ukraine unless a certain prosecutor is fired, and it is often held up as evidence of Joe Biden having been the corrupt one.
Mm-hmm.
When
did he say that?
He said it while he was vice president, and while he was trying to get Ukraine to fire corrupt prosecutors, refusing to investigate companies like Burisma, the energy company that his son was on the board of. Now, do I think I'm going to convince anyone in the right-wing media ecosystem that that is true? No, but that's true. When Biden threatened to withhold aid, it was in a legitimate effort to stem corruption in Ukraine. When Trump did it, it was an open solicitation of corruption in Ukraine. But he would have you believe it was not. And in fact, it was a perfect phone call, and it is the job of the United States to seek and stop corruption anywhere. What ultimately the line was is that, like, it was a perfect phone call, and there was no quid pro quo. Quid pro quo meaning you do this for me, I'll do that for you, because it was all implied. According to congressional Republicans at the time, the standard for a quid pro quo would go something like this. Hello, Ukrainian president. I am United States president. I would like to engage you in a quid pro quo. Here comes the quid pro quo. For your quid of investigating my political opponent, I will pro you the military assets that we said we would. Unfortunately, even Donald Trump is smart enough not to fucking do that. So it wasn't that obvious. But if you read the transcript of the call and you pay attention to like the concept of context, it's very clear what's happening here. And ultimately, he was acquitted, so whatever. Democrats got a lot of shit for being too slow during that process, so they got a lot of shit for being too fast in this one. We're in the weeds.
Yeah.
We are in the weeds. I want to return to the phrase high crimes and misdemeanors. Our conversation that we just had relates. But I want to unpack the word misdemeanors. So bear with me. I did some research from the good old Merriam-Webster dictionary. I don't know if Merriam-Webster has a liberal bias. Someone somewhere may accuse it. Let me know if Merriam-Webster's a raging liberal. But I'm quoting from the article Word History, Misdemeanor. So this is the history of the word misdemeanor. Mm-hmm. Quote, not always a crime. Misdemeanor comes from demeanor, which means behavior towards others or outward manner, as in his quiet demeanor. Demeanor derives from the verb demean, which means to conduct or behave oneself, usually in a proper manner, not to be confused with the other much more common verb demean, which means to lower in character, status, or representation. These two verbs are spelled the same way, but come from a different root. So misdemeanor, the former, the first one, comes from the Latin root meaning to conduct or behave oneself. On a linguistic level, the word misdemeanor historically has not had to do with a crime. It has had to do with the comportment of oneself.
The way you conduct yourself in life.
Right. So you have demeanor, which is the way you conduct yourself, and mis meaning like bad. If you misrepresent something, you represent it incorrectly. If you're embodying the concept of a misdemeanor, you are carrying yourself incorrectly.
Yeah, and misdemeanors became a thing in the 1990s, you said? We had a conversation sometime this week that I'm like, thinking about it in my brain, but I'm like, he's gonna bring it up. So
I was going to bring it up right now, so that's perfect. It isn't the 90s, but... So one part of my argument on the phrase of high crimes and misdemeanors hinges on the Latin root of the word, meaning to comport oneself, behavior. Then you have this other concept, misdemeanor as it is understood within criminal law, as in felonies and misdemeanors. Now, I did some research. This is from encyclopedia.com. Someone let me know if encyclopedia.com is a liberal hive, but I've thought encyclopedias are sufficiently nonpartisan. This article was called Criminal Law Reform, Historical Development in the United States. And this is what it says. The term misdemeanors, as it relates to crimes, like I mentioned, felony and misdemeanor classifications, was not a term in criminal law when the Constitution was written or adopted. It came about in the mid-1900s as something that was called the Model Penal Code. So, keep in mind, anyone that's saying that they want to interpret the Constitution as it was conceived by the Founding Fathers, and that misdemeanor means a crime, they're off by they're off by about 200 years in terms of when that word misdemeanor entered the legal code. So, a little bit about that. In 1923, there was a group of lawyers, judges, and legal scholars that got together. They called themselves the American Law Institute, and they wanted to clarify and improve law, the criminal law, because state to state they found that it was highly variable, and so they sought to seek reform. Unfortunately, there was this little old thing called the Great Depression that hit. And
this little thing.
Little tiny
I don't know if
thing.
You've ever heard
You might
of
have heard of it. It happened in 1929, and it was a disaster.
That's why there's no sequel to The Great Gatsby.
Sure. So, because of the Great Depression, this group did not get any funding until the 1950s, when the Rockefeller Foundation provided it with a grant. And
when you say Rockefeller, we're talking about New York City ice skating rink, Rockefeller Plaza.
I'm talking
that Rockefeller.
I'm talking
family.
about the Rockefellers with hella rocks, lots of money.
Mm-hmm.
Yeah,
they are fellers.
Those fellers, boy, do they rock.
rock.
I don't know if they rock. But they did fund this organization, and they formed an advisory committee made up of distinguished scholars in the field of criminal law, and they wrote this legal code. They started in 1952. It took 10 years until 1962, and there were multiple drafts circulated for comment after the debate in the project's advisory committee and on the there were multiple drafts circulated. That's really all that matters.
Quick question about misdemeanors.
Yes.
Those became a thing in general at the same time, or no? Because I remember we were talking about off the podcast about how misdemeanors were made so that like state to state there was crimes were held at like similar weights.
Yes. So the misdemeanor classification for definition, is a crime that is considered lesser in comparison to a felony and would result in a prison sentence less than 1 year, whereas a felony would result in a sentence exceeding 1 year.
Mm-hmm. So that happened before this law?
No, it was a part of this reform,
after.
And it didn't happen until it didn't come about until later. But it was part of the reforms presented by the American Law Institute and what they drafted called the Model Penal Code.
Yeah, and this was so that, like, if someone robbed a bank in Connecticut versus robbed a bank in Missouri, like, they had the same weight to them.
It was that, and also it broke down the criminal charge of theft into more specific categories. So, like, before, the law would just accuse you of theft, but this the Model Penal Code broke theft into things like larceny by trick, false pretenses, embezzlement. So you get these different categories of theft that are regarded differently under the law. Like armed robbery in the case of a bank robbery is treated differently than like embezzlement. In America, we don't prosecute a white-collar crime. Yeah, no, all that is illegal, and we don't prosecute it. I'm generalizing. I'm painting with a very broad brush, but I'm also
Martha Stewart went to jail, Skydoge.
What?
Don't take that away from her. She insider traded, right?
What the hell are you talking about?
Martha Stewart. That was a white-collar crime that she did.
Oh, did you say? I thought you said your sister. I was like...
No,
your sister was involved in insider trading? Yes, Martha Stewart was involved in insider trading.
And she did do her time.
She did time. She did time. And now...
So yeah, don't erase her experience.
I am sorry for erasing the experience of...
Martha Stewart.
Thank you, I forgot her name.
My sister.
Yes, your sister Martha Stewart.
So in the 50s and 60s, they were working on this thing with the Rockefellers.
The Rockefellers funded it. And the project overall sought to bring, this is a quote, greater rationality and fairness to the sentencing of those convicted of crimes. It proposed a scheme of determine sentencing, under which all felonies were classified into 3 punishment categories, and all misdemeanors went into 2. The upper and lower limits of sentences were set out for each category, with the determination of the exact length left to the discretion of the judge. So that was the idea, right? And they didn't really expect it to actually be implemented. Mm-hmm. But over time, it was. In 1966, Congress established the National Commission on Reform of Federal Criminal Laws to examine the state of federal penal law and propose reformulation. I'm again quoting from the article. In due course, the commission provided a thorough revision of federal substantive law of crimes, and several bills were promptly introduced for the enactment of some version of it into the law. So basically, Congress, having noted the progress of the American Law Institute, took up a investigation of the federal laws and found need for reform. By 1980, I quote again, in large part owing to the Model Penal Code's example, some 30 states had adopted revised criminal codes, and another 9 had code revisions either underway or completed and awaiting enactment. So by 1980, the concepts put forth in the Model Penal Code are finally being adopted more broadly. And one of those concepts, very importantly, is the classification of crimes as a misdemeanor. So that happened sometime between 1960 and 1980. Not anywhere close to 1789.
I'm a constitutionalist.
I'm a strict originalist that believes in an interpretation that hinges on the development of legal code 200 years after the drafting of the Constitution. You know, just like all of our founding fathers would have wanted.
Yeah, so basically the point you're trying to drive is that it's extremely hypocritical to say you believe in something from, like, the Constitution from whatever the Constitution was made. 17, whatever the fuck.
So my position, this is my opinion. Here it comes. I'm denoting it. So, I am of the belief that any Republican that is making the argument that they are an originalist and should interpret the Constitution as it was conceived in the 1700s, while simultaneously putting forth the argument that an impeachable offense must rise to the level of a criminal offense, is either 1. A fool who does not understand the history of the United States, the Constitution, and the development of criminal law. 2. Someone making a bad faith argument. Or 3. A fool making a bad faith argument. That's really all I see here. When the Constitution was drafted, the word misdemeanor did not have any attachment to the legal code. It simply did not. It had a meaning rooted in the Latin root, meaning to comport and carry oneself properly. Misdemeanor, as referring to a minor crime, as compared to a felony classification, was not invented and incorporated into the legal code until the mid-1900s. You missed it by about 200 years, give or take.
I don't know. It's like people who are like, we believe in the Constitution, and the Constitution, like, gives us the right to bear arms. Don't try and change anything, but this document's been changed time and time again, multiple times.
Well, through the amendment process. The Bill of Rights is...
Yeah, but it's still being changed.
It has...
Like, it's been altered.
Yeah, absolutely. As I like to say, never forget, we are the country that outlawed drinking and then said, holy fuck, that was really stupid. We should pass another constitutional amendment invalidating the one that we passed, banning the sale and consumption of alcohol.
Yeah.
So we don't... like, the process of constitutional amendment is not done as often now, but it is very much still valid. I mean, you can still do it.
In like a non-political viewpoint, more of a philosophical. There we go. Thank you.
You're most welcome.
Term. Like, people are just scared of change. Even if it's good change or bad change or any type of change, the want for things to stay the same because it's familiar to people. Like, that's what it just kind of feels like to me. Like, the security of things being the same. Even though the unfamiliar things are technically better, but also more liberal. I don't know, I just have a different mind than...
Well, yeah.
Probably half the people who stand on the right
Yeah, I think
side.
You're articulating a distinctly different worldview from that of conservatives. There's a quote from, I believe, George Will, and I'm going to look it up now so I get it correct.
People care about roots and where we came from and like, I don't know, I guess growing up with no roots, maybe I feel differently to change or something. I don't know. Or just being from the East Coast. There's so many little factors that have made my viewpoint and outlook on life so much different than, like a 60-year-old man who grew up in Mississippi.
I was so glad I looked this up because the quote is not from George Will. It is from William F. Buckley Jr., who said, "A conservative is someone who stands athwart history yelling stop at a time when no one is inclined to do so, or to have much patience with those who so urge it." So, I mean, is that the core of conservatism? I don't know, but it's certainly an influential thought.
Like the idea of, like, people holding on to the Confederacy and, like, waving the Confederate flag even though they lost. Like, why are you so obsessed with the past when it obviously failed?
Yeah, I mean, that's a whole separate issue. I don't fully understand how Southern heritage correlates with flying the colors of a failed rebel state that seceded from this country, but we've only gotten to the first clause of the Constitution, so moving on. Article 1, Section 2, Clause 5. This has to do with the House of Representatives. And it reads, and I quote, "The House of Representatives shall choose their Speaker and other officers and have the sole power of impeachment." This means that all articles of impeachment have to begin in the House of Representatives, usually on the House Judiciary Committee, where they'll collect evidence and depose witnesses. We saw that process in painstaking detail in Impeachment number 1. When that process is done, articles of impeachment are drafted, voted on by that committee, and then submitted to the entirety of the House of Representatives for a vote. They have to pass on a simple majority of 50 plus 1, or not 50 plus 1, because there are more than 100 people in the House. But 50% of the House must vote to impeach. If that has happened, the article of impeachment proceeds to the Senate for trial. One thing to note, when you are drafting articles of impeachment, each article must allege a single offense. The crimes and offenses within the article need to be non-divisible, meaning that you need to be able to evaluate the guilt or innocence of an elected official on the basis of one accusation and another entirely separately. And it can lead to senators voting to convict on one charge and not the other. Mitt Romney did this in the first impeachment trial. He voted to convict on one of the articles and not the other. Interestingly, in this second impeachment proceeding, there is a single article of impeachment, and the non-divisible nature of the impeachment article was called into question. And so we'll talk about that next week.
So do you think that happened because of how quick and rushed the second impeachment
Absolutely. In this case, the House rushed what they called a snap impeachment, which dramatically abridged the process of fact-finding and deposition in the House.
Yeah.
This was for a couple reasons. It was the opinion of the House majority that the impeachable crimes were committed on live television. We all watched it. And that they would be able to make their case using footage from the riot and establish like the mindset of President Trump using his tweets. So they did not believe that deposing additional witnesses were necessary, and that doing so would draw out the impeachment trial to the detriment of the Senate being able to pass legislation, as if the Senate does much of that anyway. But that's how they felt. Additionally, they felt there was a need for immediate action because they felt that Trump posed a direct threat to the peaceful transfer of power, and his term was expiring very soon. So, on January 13th, 1 week after the Capitol riot and 1 week before Trump was to leave office, he was impeached a second time.
And it went through the House of Representatives, like, very fast, right? And it was in the Senate that it's prolonged?
Well, the Senate trial was also relatively expedient. It passed the House of Representatives with every Democratic House member supporting it, and I believe 10 or 11 Republicans supporting it, including Liz Cheney, the third highest ranking Republican in the House.
Dick Cheney's daughter.
Yes. Very rarely do I and the Cheney family find common ground.
Yeah.
Here we have found some. And Liz Cheney has been very outspoken about that. She's faced a lot of backlash from within her caucus, who insists on loyalty to Trump. And to her credit, she has not backed down. And for a party that talks a lot about cancel culture, they tried to remove her from her spot as the third ranking House Republican and essentially cancel her for having not towed the party line. But that's their prerogative. It's their caucus. She's still the third ranking Republican. So the article of impeachment itself, the text of it, is important because it's the basis of the subsequent Senate trial. And it's the quasi criminal equivalent of an indictment. But it is not an indictment because it's not a criminal proceeding. People often compare the proceedings in the House to that of a grand jury, where a prosecutor would present a case to a grand jury prior to the actual trial. The point of a grand jury is to determine if there is enough evidence to even warrant a trial. That's essentially what the House does, but they are not required to abide by the same processes as a grand jury because it is what? Not a criminal proceeding. I intend to read the actual text of the article of impeachment at the outset of the next episode. It's 4 pages. I'll spare you it now. So, once an article is passed, it heads over to the Senate. The Senate is responsible for hearing the case brought by the House impeachment managers, hearing the defense of the accused party, in this case, former President Donald Trump, and act as a jury. They have to swear an oath. The oath is as follows. I solemnly swear, or affirm, as the case may be. They can, I guess, swap swear or affirm. I solemnly swear that in all things appertaining to the trial of impeachment of now pending, I will do impartial justice according to the Constitution and laws, so help me God. So every senator has sworn that oath as they go through impeachment.
Why is there so much religion mixed into politics when we are, like, America was founded on the idea of, like, what is it?
Separation of church and state?
Yeah, separation of church and state.
So that phrase never appears in the Constitution, but it is a foundational tenet of our
democracy.
Yeah, I mean, the right to free practice of religion is a subject in the First Amendment. So, like,
He swore on the Bible. I always think about
what is
that
that a reference to?
There's this guy who was like, I saw him swear on the Bible, and it's like he didn't swear on the Bible. You could swear on anything. Like,
Oh, yeah, you
he
can
swore on
choose which holy text you get sworn
Yeah.
in on. Yeah.
I'll have to send you that clip. It's really
I
funny.
look forward to watching it. So, when it comes to the Senate, two relevant clauses in the Constitution. They are Article 1, Section 3, Clause 5, and Clause 6. We will start with Clause 5. It reads, and I quote, "The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no persons shall be convicted without the concurrence of 2/3 of members present." So there's a couple things that that clearly says. 1, Senate has sole power to try impeachments. 2, senators must be under the oath, which I have already read. 3, if the president is being tried, the Chief Justice must preside over the trial. And for conviction to occur, you need 2/3 to vote in favor of conviction. So not a simple majority, you need 67.
And so it's not always that the House and Senate is at a constant like 50-50 divide.
No, that's actually extremely rare.
Yeah, so usually someone has some type of oh my god, what's the word?
Majority?
Yeah, usually there's a majority.
Yeah.
And right now we have majority in all three.
No, you asked me this on another episode. We still don't have a majority on the judicial branch. The Supreme Court is a 6-3 conservative lean.
Oh. Wait, but what's that have to do with the House or the Senate? The judicial branch?
Nothing in terms of
passing laws, right?
Well,
because it's not like the judicial branch has any say in like what gets passed.
They have what's called judicial review, which is the ability to review any laws passed to determine if they're constitutional or not.
So it could go through the House and the Senate, and then it could hit the judicial, and they're like, no.
That's a wonder. So laws generally, yes. Impeachments, no. And I'm glad you asked because that's what we're going to get into right now. So on the specific part of that clause, which we just read, the quote, sole power to try all impeachments, it means that the Senate is responsible for determining the rules of that trial. And this specific section of the Constitution was subject to a United States Supreme Court case called Nixon v. United States. And I know what you're thinking. It is not that Nixon. It's a different Nixon. Another Nixon that was impeached for poor governance. So, tough to be a Nixon, I guess. This was decided in... the case was heard in 1992. It was ruled in 1993 that the petitioner, Nixon, had no standing. And these are the details of the case. I'm quoting from a website called Justica, which is a resource for legal scholars and lawyers to stay up to date on case law. It quotes heavily from the decision itself. I did not read the multi-hundred-page decision myself. I'm sorry, I'm a poser. But I am quoting from the article which I read, which was about Nixon versus the United States. Quote, after the petitioner, Nixon, who was a chief judge of the federal district court, was convicted of federal crimes and sentenced to prison, the House of Representatives adopted articles of impeachment and presented them to the Senate. Then, the Senate, pursuant to what is called Rule 9, nope, that's Rule 11. Roman numerals, man.
They getcha.
Yeah, that's Senate Rule 11. So, Senate Rule 11 allows a committee of senators to hear evidence against the impeached individual, and then that committee reports the evidence to the entire Senate, and then they vote. Nixon contended that, well, first I should mention that happened. A committee heard the evidence, presented it to the Senate. Nixon was convicted and impeached. He then sued. He sued arguing that Senate Rule 11 prohibited the entire Senate from taking part in the evidentiary hearings, and thus violates the first sentence of the Constitution impeachment trial clause, which provides that, as we said, the Senate shall have the sole power to try all impeachments. In this case, the district court held that his claim was non-justicable, which means it involves political questions that cannot be resolved by the courts. It is the court saying, we do not have a right to adjudicate this. This is expressly not in our realm, or otherwise there's no reason for us to believe it would be in our realm. And I'll explain more about that. But the district court ruled that it was not something that the courts could rule on. The Court of Appeals affirmed that. Any questions before we continue? So now I would like to talk about the substance of Nixon versus the United States and how it applies to the powers of impeachment. I quote again. The language and structure of Article 1, Section 3, Clause 6 demonstrates a textual commitment of impeachment to the Senate. Nixon's argument that the use of the word try in the clause's first sentence impliedly requires a judicial-style trial by the full Senate that is subject to judicial review. That concept, rejected. The court says, nope, you are not provided or entitled to a judicial process resembling a criminal proceeding. The quote continues. The conclusion that try lacks any sufficient precision to afford judicially manageable standards of review is compelled by an older and more modern definitions in the dictionary, and is fortified by the existence of three very specific requirements that the clause's second and third sentences do impose. Those were requirements we already discussed. They were that the senators be under oath or affirmation, that 2/3 of the senators must vote to convict, and that the Chief Justice must preside when the president is tried. The precise nature of which, those three requirements having been outlined, I quote again, suggests that the framers did not intend to impose additional limitations on the form of the Senate proceedings. The clause's first sentence must instead be read as a grant authority to the Senate to determine whether an individual should be acquitted or convicted, and the common sense dictionary meaning of the word sole indicated is the responsibility of the Senate alone. Nixon's attempts to negate the significance of the word sole were unsuccessful, while his alternative reading of the word as requiring impeachment only by the full Senate is unnatural and would impose on the Senate additional procedural requirements that would be inconsistent with the three express limitations that the clause already sets out. A review of Constitutional Convention's history and contemporary commentary supports a reading of the constitutional language as deliberately placing the impeachment power in the legislature with no judicial involvement, even for the limited purpose of judicial review. End quote. So, Nixon, he was impeached, removed, and then he sued and said, I should be reinstated, all my benefits should be given back to me because the full Senate didn't hear my trial. And it went to the courts. Noted liberal activist Antonin Scalia was one of the justices that heard this case. For the listeners out there, Antonin Scalia is a diehard conservative. Rest in peace. And they determined that that is nonsense, that the Senate has the right to set out the rules and the courts have no jurisdiction over the matter.
And that's why Trump tried to stack the judicial before the judicial branch before he left office, or just so that there would, in case anything went to the court, he thought he had like that full loyalty, right?
Yeah, as someone that had never read the Constitution, as it seems very clear to me Donald Trump never did, I think he believed that the courts would ultimately save him. Mm-hmm. It doesn't really work like that. So Trump was able to confirm a record number of judges because McConnell, as Senate Majority Leader in the final years of Obama's administration, refused to allow confirmation of judges. And so there were these artificial vacancies.
It's too late. You're only going to be president for a few more months.
Yeah, whatever bad faith argument he was mounting at the time, ultimately, they left vacant a ton of judge vacancies. And so Trump was able to come in with this artificial bevy of empty slots, and the Senate made great work of confirming them. Mitch McConnell's goal was not to protect Donald Trump in that instance. It was to put on the bench conservative judges that would be there for a generation and alter the scope of government in perpetuity.
Yeah.
And I think it was his legacy move.
So literally the only thing that could change Republicans having that majority in the judicial branch is death. Right? Or if they
judges can retire. Judges can retire. They can be impeached if there's proper cause. They can be.
Oh dang!
Yeah,
anyone. Can
Any civil officer is subject to impeachment. There have been
I didn't know
4 presidential impeachments. Nixon was not impeached because he resigned before he was impeached. But there was Andrew Johnson, Bill Clinton, and then Donald Trump twice. There have been significantly more impeachments in the Senate of people who weren't the president. But finally, on the point of Nixon versus the United States and the question of whether or not the courts have a right to enter into this process, they say that right of the court is, I'm quoting, negated and refuted by 1. The lack of finality inherent in exposing the country's political life, particularly if the president were impeached, to months or perhaps years of chaos during judicial review of the Senate's impeachment proceedings, or during any retrial that a differently constituted Senate might conduct if its first judgment of conviction were invalidated. And, by 2, the difficulty of fashioning judicial relief other than simply setting aside the Senate's judgment of conviction. So basically, the court is saying, there are 2 reasons why we cannot assert our power over the Senate's power to try impeachments. 1, if we do that, if an impeachment trial is allowed to be thrown into the courts, it will take years, months and years. It will be an incredibly painful, drawn-out process. It actually happened in the first impeachment when Democrats were trying to subpoena people to testify who were then asserting executive privilege. Don McGahn's subpoena for the first impeachment is still being adjudicated. So I understand the hesitance of House impeachment managers on the second go-round to call witnesses, because that is a lengthy process. The other point was that the only thing that the judicial branch could essentially do is completely invalidate what the Senate had decided, and that is not pursuant to the Constitution. So they have said, we can't adjudicate that. So this is like a case which demonstrates that the court says we have no place in impeachment proceedings because they are what? Not criminal proceedings. And when it came to the question of witnesses in the second trial, there was this idea that maybe we'll call one witness, and there was a threat on the part of Senate Republicans that if you do this, we will grind the Senate to a halt. We will not discuss COVID relief legislation. The president's lawyer, as we will discuss next episode, said if we're calling witnesses, he's gonna subpoena 100 of them. He's gonna do his job to find the facts, and that is what they discussed during their quorum call. And they worked out a deal in which they would not call witnesses, but they would read into the record this particularly damning statement about Donald Trump. That's all I got to say on Clause 5. You ready for Clause 6? Mm-hmm. So this is Article 1, Section 3, Clause 6.
Except for the fact that I just heard the other day the 1.9 trillion COVID relief bill was passed. So I'm like, I wonder if that happened because of something that happened during the impeachment trial.
Yeah, I think it did. Because Senate Republicans were saying that they refuse to walk and chew gum. They will not engage in impeachment and legislating at the same time. This was exacerbated by the vow of the president's lawyers to depose hundreds of people, and Democrats just didn't see any upside to it. Moving on. Article 1, Section 3, Clause 6. continues, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, and judgment, and punishment according to law. So, this clause establishes two things about Senate impeachment proceedings. The first thing is that in the event that a civil officer is determined guilty, the Senate has two options in terms of punishment, and two options only. They are, 1, removing that official from office, and 2, disqualifying that person from ever holding office again in the future. Once again, they do not have the right to impose any criminal penalties or send anyone to jail for any amount of time, because it is what? A political proceeding. This is a subject of contention in Trump's second trial. The defense asserts that you can't disqualify someone without first removing them from office. And in this case, the Senate can't remove him because he's not president anymore. So therefore, he can't be disqualified. In their view, disqualification is contingent upon removal and can only be invoked in conjunction with the act of removal. And in their view, with nothing to remove, there's nothing to disqualify.
Yeah, and that's why they needed to do the second impeachment so quickly, is because they only had X amount of time while he was still sitting.
Well, that's exactly right. They impeached him for actions he did while acting as president, and the impeachment was passed during his time in office. The Senate, then run by former Senate Majority Leader Mitch McConnell, refused to reconvene the Senate for an emergency session. He argued that there was no way to carry out the trial in the remaining week. The trial lasted 5 days. Now, I'm not a numbers guy, but I do believe 5 days is less than 7 days, and thus it could have probably happened. To be fair, that would have left very little time for both sides to put their cases together. It would have been very rushed, a process, but don't tell me it wasn't possible. You had 7 days and you got it done in 5 after the fact, so... This ultimately leads the president's lawyers to decry the entirety of the second impeachment proceedings as unconstitutional. They call it constitutional cancel culture, which is one of my favorite things ever. First, there's just so much about this that is surreal. Tweets are evidence, and there's this concept of cancel culture invoked within the Constitution. It's just so bonkers to me.
It's literally tea and gossip, but you could go to court and jail.
Say more.
Like how I feel like if people looked at politicians as celebrity, which I mean, should you not? There's definitely a moral compass to play along with that, but if you think about how people get so invested in celebrities' lives and read their tweets and go through their dramas, it's basically the same thing except with no true consequences. But in government, it's like all this stuff has real, solid meaning. Well, I guess not, since Trump...
Yeah, no, there's no accountability.
Got acquitted twice.
Yeah.
I guess it doesn't matter. Never mind.
Well, no.
Redact
No,
that.
I can, but the fact of the matter
No, you
is,
don't.
like, Trump was also a unique president. He was the Twitter president in that, first off, he was a celebrity prior to being president. It was his only qualification for the presidency. And he behaved like an unhinged celebrity, tweeting in all caps at all hours of the night. So, like, that new development of it feeling like gossip, but in a court of impeachment, is unique to Donald Trump and his conduct.
Yeah.
It lends itself to that. So, in opposition to the president's lawyers asserting constitutional cancel culture, it is the view of the House managers that disqualification is not contingent upon removal. The Senate has two remedies, removal and disqualification, and the invocation of one, in this case disqualification, does not require the other, which would be removal. You can't remove someone who's gone from office, but you can stop them from serving ever again. And this is where we dicker over the presence of a comma and the conjunctive and as opposed to or. Constitutional law is really fun.
It's super fun. Everybody loves it.
The second thing established in this clause of the Constitution is that an impeached individual is still able to be prosecuted in a criminal court of law via the judicial branch of our government. So there's this concept in our legal system called double jeopardy, which is the idea that you cannot be charged and tried for the same crime twice. So if the government brings charges against you for a crime, there's a trial, you are found not guilty, the government cannot decide later to try you again. Say the government found new evidence. They are not allowed to try you for that same crime. They already tried once. You cannot do it again. That's called double jeopardy. It protects people, but it does not protect people who have been impeached. This further suggests that criminal proceedings, which invoke the concept of double jeopardy, and impeachment, which does not, might be different than a criminal proceeding. Maybe it's a political process. I don't know. I do know it's a political process. So impeachment's clearly not a judicial proceeding because double jeopardy doesn't get invoked. And in explicitly maintaining the right to criminally prosecute an impeached individual, it's my interpretation that the processes are thus explicitly separated.
So Trump can't technically be charged criminally by the United States government, but he could be by like New York City.
No,
or
he can be
Florida.
charged by the United States government. The U.S. Department of Justice can charge him of federal crimes if they find sufficient evidence.
Oh, okay.
He is also subject to criminal charges on the state level. And we will talk about this in the next episode as well. Mitch McConnell voted to acquit Donald Trump on the argument that Donald Trump is guilty.
That makes zero sense.
I sent you the speech. You didn't do your homework and listen to it, but
I need to watch.
I know you'll do it by the next episode. He basically falls back on this question of jurisdiction, which we'll discuss in the next episode as well, as to whether or not the Senate has any right to adjudicate this because he's not president anymore. So how can you impeach a former president? So in McConnell's view, he gives a speech after voting to acquit that there is no question that Trump played a role in directly inciting the attack on Congress, and he kicks it to the criminal branch. He's like, and he's not gotten away with anything yet. He can be indicted.
So basically, Mitch McConnell was like, I can't fully betray this man, but I could lead you to a way where you potentially can.
Yeah, I think it was one of the most eloquent dereliction of duties and abdication of power that I've ever heard. Like, he's basically saying, Trump is guilty, but I'm not going to do anything about it. I'm going to kick the can to the judicial system. Now, this makes me a little uncomfortable, and we'll revisit this next week, but in the case of the Mueller investigation, the Justice Department appointed an independent special prosecutor to investigate Trump's conduct in relation to the Russian probe regarding election interference. It was the determination...
So basically...
Go ahead.
No, go ahead. So basically, we're not done with Trump.
I mean... What do you mean?
Like, is the judicial, or is it criminal, is he gonna, like how Mitch McConnell passed it off?
So, he is still subject to these criminal proceedings. There was recently a ruling from the Supreme Court that the District of Attorney, the Southern District of Manhattan's District Attorney, has every right to acquire Donald Trump's tax records. This was a huge fucking fight during his presidency.
I remember that. He, like, paid, what, $700?
$750, yeah. The reason I'm uncomfortable with Mitch McConnell deferring to the criminal justice system is that Mueller, as an agent of the criminal justice system, determined that Trump had obstructed justice and that it was the responsibility of Congress to do something about that. That there was a memo in the Justice Department that says a sitting president can't be indicted, and therefore a special prosecutor cannot make a determination as to whether or not he ought to be indicted. So it was kicked to Congress, and they didn't impeach him. So there you have the criminal system kicking a question of presidential abuse of power to Congress. Congress, then led by Democrats, abdicate the responsibility and chance to impeach him. They later impeach him about this Ukrainian phone call. He's acquitted. He's later impeached for inciting a violent attack on Congress. He's acquitted, and the can is kicked again to the criminal justice system. Now, there might be a better outcome now that he's not president. Being president comes with certain legal protections that he's no longer entitled to. That's evidenced by the fact that his tax returns have been turned over. But do I feel like there's going to be accountability? Color me skeptical.
I feel like that's fair and valid to not have high hope.
So, what is important to understand about this clause is that the outcomes of the two processes, those processes being the political process of impeachment and the criminal judicial process of prosecution, have entirely unique outcomes that do not overlap. And thus, those two powers are in two different branches of government. So we have Nixon versus the United States, which establishes that the judicial branch does not have a place to insert itself in the Senate's proceedings, and you have a clear process where, or a clear statement. You have a clear statement in the Constitution that impeached individuals can still be criminally prosecuted. Therefore, it's reasonable to assume the two processes are separate and distinct. Does that make sense?
Yes.
Tell me if it doesn't.
I think that makes sense to me.
Does it make sense to you, listener? Blink once if it does. Okay, moving on.
Scream into the void if that makes sense.
Scream into the void by tweeting at me.
At
Skydoge Bubble, SKYDOGE Bubble, on all platforms, or emailing me at skydogebubble@gmail.com. So, I just want you to keep this concept in mind, that these processes are entirely different. The judicial process of criminally charging someone with something and the political process of impeaching someone for an impeachable offense, entirely different. And it will become relevant next week when we discuss the president's defense, which relies, among other things, on a criminal definition of incitement as determined and arrived at via the 1969 case Brandenburg v. Ohio. It establishes a three-part test to determine if speech rises to the level of criminal incitement. Unfortunately, criminal incitement is not the question at hand. Criminal anything is not the question at hand, I would assert, because this is a political process about the conduct of people in office. So, whether or not it meets the criminal definition of incitement isn't necessarily relevant to the facts of the case, because he gave a speech as president urging a protest on Congress to fight like hell to stop the steal. We'll talk more about the speech next week, but then there was a fight like hell to stop the steal. The president's lawyers will try very hard to have you view his speech in a vacuum. The House managers go to great lengths to put his speech in a greater context of Trump's anti-democratic behaviors and statements. So just keep this in mind, the difference between a criminal proceeding and a political one. Additionally, just like a fun thing, the three-part test, the Brandenburg test that the president's lawyers lay out, they assert that Trump doesn't even violate or clear the first bar, which is like explicitly or implicitly urging the use of violence. And I'm like, oh, honey, you're wrong. The word
he does
all
that
the time, implicitly.
They
They cite that, and then they go on to say he never explicitly said it and ignored the word implicit in that sentence. again, we'll get to it next week. I'm sorry to tease you so, listener. You're so teased.
Little tease, you're so
yeah,
teased.
Call me a tease. I don't care.
You're looking like you're looking like Farrah Fawcett with all that tease.
The final thing that I want to mention that comes from the Constitution, and that I think will ultimately be relevant to our analysis of the second impeachment of Donald Trump, is the third section of the 14th Amendment of the Constitution. The 14th Amendment was passed in the wake of the Civil War, and it reads as follows, quote, "No person shall be a senator or representative in Congress, or elector of the president or vice president, or hold any office, civil or military, under the United States or any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability." Basically, if you led an insurrection or rebellion against the state, you can't be a civil officer anymore. This was very relevant when the Confederacy was just defeated in war. I think it still applies when a executive gives a speech delegitimizing the results of the election and calling upon his followers to march on Congress to stop the steal. Whether or not that is a insurrection or rebellion, I suppose is subject to debate, but one branch of government was attacked at the urging of another branch of government. Or it was an incredibly perfect speech. Nothing was wrong with it at all, depending on what world we live in. Our realities have entirely diverged. I feel great. Everything's great, and I'm very happy. This episode made me very happy.
Woo!
So, I hope you've enjoyed this episode of The Liberal Bubble. It was heavy on constitutional quotes, and it lays the groundwork for a future episode. The next episode, where we'll get into the substance, the nitty and the gritty of the arguments of both sides in this impeachment. So look forward to that. That'll be coming to you next Tuesday.
We'll see you next Tuesday, listeners.
I'm Skydoge, signing off. As I mentioned earlier, find me at Skydoge Bubble on any platform. And Lady Gleep, where can they find you?
Lady Gleep, find me on Instagram, TikTok, Twitter, at Lady Gleep. And that's where I'll be.
That's where we'll be. And we'll see you next week in this tub on Tuesday. Bye now.
Goodbye.